A federal judge in Boston has ruled that American Airlines and JetBlue Airways must end their partnership in the Northeast United States. The judge determined that the collaboration between the two airlines, known as the Northeast Alliance, violates antitrust laws and reduces competition in the airline industry. The ruling is considered a significant victory for the Biden administration, which has been actively using antitrust enforcement to combat mergers and agreements among large corporations. The Justice Department, during a trial last fall, argued that the partnership would ultimately lead to increased costs for consumers, amounting to hundreds of millions of dollars annually. U.S. District Judge Leo Sorokin, in his decision, stated that American and JetBlue had divided up the Northeast markets and replaced robust competition with broad cooperation, providing minimal evidence that the alliance benefited consumers. While American Airlines and JetBlue Airways are contemplating whether to appeal the ruling, they expressed disagreement with the decision. American spokesman Matt Miller claimed that the court's legal analysis was incorrect and unprecedented for a joint venture like the Northeast Alliance. The airlines maintained that there was no evidence of consumer harm resulting from the partnership. JetBlue spokeswoman Emily Martin expressed disappointment and emphasized the positive impact the Northeast Alliance had on customers. Attorney General Merrick Garland praised the ruling, considering it a win for Americans who rely on competitive airlines for affordable travel. The partnership had initially received approval from the Trump administration when it began in early 2021. Under the alliance, the airlines were able to sell seats on each other's flights and share revenue. The agreement covered numerous flights to and from Boston's Logan Airport, as well as 3 airports in the New York City area. However, after President Joe Biden took office, the Justice Department re-evaluated the partnership and discovered an economist's prediction that reduced competition would result in consumers spending over $700 million extra annually. The Justice Department, joined by 6 states and the District of Columbia, filed a lawsuit in 2021 to block the deal. The trial included testimonies from current and former airline CEOs, as well as economists who presented varying opinions on the impact of the partnership on competition and ticket prices. The airlines and their expert witnesses argued that the alliance had not led to higher fares and had facilitated the introduction of new routes from New York and Boston. They also claimed that the partnership benefited consumers by creating more competition against other major airlines. However, the judge was not convinced by these arguments. He stated that the defendants had provided minimal credible evidence to support their claim that the collaboration would benefit the flying public. According to the judge, the benefits the airlines derived from their increased market power were a result of an agreement not to compete with each other. The trial's outcome was also influenced by JetBlue's proposed $3.8 billion acquisition of Spirit Airlines, the largest discount carrier in the country. While Judge Sorokin deliberated on his decision, the Justice Department filed a lawsuit in March to block the JetBlue-Spirit deal, citing concerns about reduced competition and the negative impact on consumers who rely on Spirit for affordable travel. JetBlue argued that the acquisition would enhance its position as a low-cost competitor to other major airlines. The government's lawsuit against the JetBlue-Spirit deal is currently pending before a different judge in the same Boston courthouse.